17, pages 10 to page 14, paragraph 22 to 36 of the answering affidavit. It is correct that under the rubric of agency, we would like to address 4 issues which have been raised. The first issue which we raised in the answering affidavit is that agency in this court has dissipated from the agency that once was in the Constitutional Court. And we make the point in paragraph 32 of our answering affidavit that was so because of the applicant's adoption of a bad legal strategy when they approached the Constitutional Court for direct access in circumstances where their claim to direct access and exclusive jurisdiction was precarious. And the point we make, lady, is that it was open to them when approaching the Constitutional Court to approach litigation in belt and braces, to approach the Constitutional Court conditionally on the basis that they will approach this court and only access jurisdiction of the court or direct access to the court if this court does not exercise or does not hear the matter, or vice versa, to approach the Constitutional Court on the basis that they will tell this court, if they approach this court, that the matter has been seized or has been accepted by the Constitutional Court. They adopted a bad legal strategy in not adopting that approach, because if they had done so, then the outcome that ultimately came from the Constitutional Court, where the Constitutional Court declined jurisdiction, would have left available the remedy of them coming to this court at that time. You recall, my lady, the reason why they approached the Constitutional Court and the agency was claimed at that time was in anticipation of the Madaga's Commission, which was due to start on the 1st of September. 1st of August, I'm sure. It was 1st of September. That was the anticipation. And the Constitutional Court created the regime for the entertainment of the matter up until, as it were, 31 of July. I think the reference is correct in 1st of August. But then there was a postponement, which is irrelevant, which is now being sought to be introduced by internal application. But the point of it is that the anticipation and the urgency of the matter arose from the fact that there was a Madaga's Commission which was due to start around the corner. And also, the urgency arose because Kachala's appointment was due to take place on a day, like the 1st of August. So the matter remained urgent in the Constitutional Court, and we did not take agency at that point for that reason. But once the Constitutional Court declined to exercise jurisdiction, the agency that there was dissipated. And I'll deal with this with reference to the chronology, and that's the second part of my argument. The chronology of the matter indicates that the decisions which are reviewed in this case were taken on the 13th of July, and you'll see this in the chronology in folder 14. So it's folder 36, page 3. And the judgment or the decision itself is in MK2, bundle B, at folder 15. The next timeline that is important is the 18th of July, when the applicants approached the Constitutional Court. And you'll see that in the chronology at page 5, sorry. It's the folder 36. And we know that in the Constitutional Court, the President took the point on jurisdiction and direct access when it's filed its answering affidavit on the 23rd of July. So it must have been clear to them, at least as early as 23 July, that their jurisdiction and access or direct access to the Constitutional Court was precarious. Even at that point, it was open to them to approach this court and say, look, the President has taken jurisdiction and direct access. In case we fail, we want to preserve our agency and come to this court. They didn't do so. The next timeline is 8th July, when the Court heard the matter, and 31 July, when it ordered, it delivered its order, declining to exercise jurisdiction and not to hear the matter. We know from that date that the applicants waited for 12 days thereafter, knowing that the matter is urgent, and far away from the time that Kachala was supposed to take office, or rather when the Madaka Commission was supposed to take place. But we know that, the timeline is that on the 1st of August, I think Professor Kachala took office. On the 1st of August. But Madaka Commission was due to start a month later on the 1st of September. It didn't start for one or other reason. That was the anticipation, one of the anticipated events. So at least by the 12th of August, the urgency of this matter had dissipated. First because by that time, Kachala had already been appointed. 2, the date for the hearing of the Madam Commission had been identified. It was the 1st of September. But knowing all those events were upcoming, the applicants waited for 12 days from 31 July and only launched this application on the 12th of August. And in the process constrained the respondents to deliver answering affidavit in severely truncated timelines. I think the first and second respondents were given 2 or 3 days to deliver an answering affidavit on a case that had, as Malal friend says, repackaged. It was not, and Mr. Blake, it is not open to this court to allow the applicants to do this and to trample without explanation why such truncated timeline should be observed and imposed on the respondent to answer this case. The result is that something was done by the respondents to try and meet with the timelines and the facts which needed to be placed on record. As it now turns out, with reference to the interlocutor application, had not been placed on record. So it is unfair for the respondents to have been placed in this impossible position to answer a big case like this in a severely truncated timeline without an explanation why this matter should be dealt with on an urgent basis. So, my ladies, you are right when you say this case must be decided first and foremost on whether it is urgent or not, given the circumstances which have come before now, when the matter was litigated. Not only before now, when the matter was litigated in this court, but also how the matter was litigated in the Constitutional Court. Agency raises its argument in this case. More so because the respondents have not been placed in a proper position to deal with the matter comprehensively. Now, thirdly, and I don't want to deal with this point, the point of absence of allegations or traversal of the requirement of in this court that the applicant who comes to this court must at the very least demonstrate that he would not be afforded substantial redress in due course. Not even a sentence is dedicated to them. But we know, as Benefit has said, that there is substantial redress in due course. Because under the, if this application is pursued on rule of law grounds to vindicate the rule of law, which is an incident of constitutional, principle of legality and constitutionality. If that is the point, under the rule of law remedies, there are a number of remedies available to the applicant now and later, which will accord substantial vindication of the rights of the applicants in this understanding. In due course, in the applicant's application, there is no engagement, not even an attempt to engage with these requirements. With the result that this court is entitled in our submission to return a verdict that it does not have to deal with this matter on an urgent basis. Finally, we have heard today from Malena Fred that reliance is made to the 121 dockets which have were removed from the political task teams by the minister as a basis for agency. It says that's abuse of court. That you will not find in the final affidavit. That's the unfairness of this agency, to now try and run the argument and agency on the basis of an argument that was never raised in the founding affidavit. The point about this 121 dockets argument, which has been raised for the first time in support of agency in this court, is now submission nothing else but to sensationalize the matter in order to align and avoid a legal issue of agency. The dockets, the 121 dockets, are a subject of discussion in the Madam Commission now. And that's the point. Why the President referred the matter to the Madam Commission, to have those matters play themselves out and dealt with in the Madam Commission. And that's where they belong. And the country today is hearing evidence of that part, at least on the part of Mkwanasi. There's so much furor around it until Mr. Mkwanasi, or Lieutenant General Mkwanasi, is cross-examined. But that is where the issue of the 121 belongs. It cannot be and should never be, and was never made, a basis of agency to this court. So we submit to my ladies that the point of agency has been well taken, and this court should decline to entertain the matter urgently. We can wait for a day, another day, when rule of law arguments which are raised in this case can be raised properly. When all information, including the information that the applicant wants to introduce to this court for an interlocutor application, has been properly ventilated, including the ventilation of the issues, the very issues that Madam relies on for agency, have properly been ventilated before Madam Commission. This is not the time, not an occasion where this matter should be heard on the matter of agency. So those submissions will say the matter is not agency is well taken.
Thank you, Madam Sir.
I'm getting used to not being asked questions.
Yes, Mr. Replies.
Yes, I'll be well, my learned friend is anyway, let me just deal with this firstly, just the factual misrepresentations, so that we get that out of the way. My learned friend, Mr. Manyeche, really fudges a very simple issue by clever lawyering. So he says that the issue of agency was raised in the Concord. Well, that's simply not true. You must just look at the answering affidavits in the Constitutional Court, both of them. Look for the word agency. You won't find it. Because Mr. Majotela, as he correctly points out, considered agency openly and Mr. Maineja simply failed to raise it. That's it. So the reality is this: it doesn't work the way he's trying. It's actually a very creative argument. So he's saying, because one of the factors when you deal with direct access is the importance of the matter and its agency and so on. So somewhere there was hidden. When they said there's no direct access, they meant also that there's no agency. But that argument doesn't work if you think about it. Because what he has forgotten is that direct access is all in the Constitutional Court, is always argued in the alternative. So you start by saying this court has exclusive jurisdiction. But if I'm wrong, then direct access. So the court would not have reached the exclusive jurisdiction if what my learned friend is saying. Let's forget about direct access. Let's assume we didn't even ask for direct access. The court there would not have even reached the exclusive jurisdiction if it thought the matter was not urgent. So his argument falls flat, creative as it was intended to be. Then he says, which is not true, and my learned friend knows this, he says the reasons that we asked for in our letter of the 4th of August, I'm going to quote him verbatim, reasons were given for all the challenges. That can't be true, logically. How could the president on the 20-something of July have given us reasons about what was going to happen on the 1st, about the minister of that portfolio, the swearing in, the change of titles, and all the things we complain about? How could you, unless if the president is a someone, that we knew that on the 1st of August there'll be all these other things that are happening? It's impossible. That's why we were asking the questions. Because we're saying, this is now what has happened, tell us A, B, C, D, or whatever. So that's just simply false.